Hello and good afternoon. This is Bernard Wolfsdorf. I welcome you to our hastily gathered Hot Topics webinar. For those of you who are California attorneys, you are eligible for CLE credit. Sorry, my slides are going off on their own somewhat. There we are, back in control. So many of you are familiar with basically what happened. AILA had its EB-5 conference in Chicago on August 23. I had the privilege of presenting the China panel with two of my colleagues and with Charlie Oppenheim, the Director of Visa Control for the State Department. 1 minute prior to the panel commencing, Mr. Charlie Oppenheim, do we have a technical issue here? No? Thank you. Sorry about that. Just my tech specialist is having some fun here. So about 1 minute before we went live, and I gather quite a few of you were there, Charlie gave me a little piece of paper and kind of a little bit of excitement and drama because he announced that for the first time the quota basically will be reached for this fiscal year. This wasn't really dramatic news. We kind of knew that it was going to happen, but the interesting part about this is that even though we will use up the full 10,600 visas that are available, we can explain why there's a couple hundred extra later, it's not really a crisis. We do not have a crisis. There is no crisis for this year. And we need to make that very, very clear. The China EB-5 visas will basically not be available for August and September. It simply is a warning for what's going to happen in the next fiscal year. And we're going to examine that during the course of this webinar. And we encourage all of you to submit your questions. There are a lot of complicated questions, and it's suddenly become very important to start planning. And there's a lot of math involved in this. So being a lawyer, I'll probably need to use my calculator or have to take off my shoes because I can't count past 10 without a calculator. Sorry, bad lawyer joke. We'll try and avoid the lawyer jokes and focus on this very important topic of understanding the cutoff dates. One of the things that I'm going to talk about again is the term retrogression. Everybody's describing this as a retrogression problem. Let me just be very clear. This is not a retrogression problem. We've been using the word incorrectly. Everybody's been using the word incorrectly. We're going to go through the term retrogression. Retrogression is where you are already backlogged. For example, sometime in May 2015, we expect the Chinese EB-5 quota to be backlogged. And once it's backlogged and it goes from May 2013 to April 2013, so once it goes from a 2-year waiting line, 24-month waiting line to a 26-month waiting line, that is called retrogression. We don't have any retrogression at the present time, and there are specific consequences that apply to retrogression. For example, it cuts off the 1-year seek to acquire clock and effectively gives you or restarts that clock. So if the priority date is not available within 1 year, that a retrogression can effectively allow you to restart the clock, and I'll get into that in some additional details. So the most important impact of this particular development is how to prepare now for the coming establishment of a cutoff date in April or May 2015. Now, how do I know this date? Well, I know this date because the State Department has been unofficially telling me about this date. However, they do not know. And it's very important to understand that the difficult part of the planning is because we don't know how deep the cutoff gap will be. The million-dollar question in all of this is, what is the cutoff gap going to be in May 2015, next year, or April 2015, whenever it's established, or maybe it'll only happen in June, or maybe it'll happen in March. But my prediction is it's going to happen in one of those 3 or 4 months, most likely in April or May. And we will get some advance notice. The State Department will tell us 2 or 3 months before. However, those of us who are filing I-526s now need to make a decision now. And the question is, what do you do when you have an 18-year-old derivative, a 19-year-old derivative, or a 20-year-old derivative? And I think I can answer that question in regard to a 20-year-old derivative very easily. And that is, file as the principal. The 20-year-old has to be the principal. Now, even that bold statement, and by the way, I'm not giving legal advice, blah, 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 blah. I've got all these disclaimers. So this isn't legal advice. This is just Bernie speculating. But I do think I have some decent knowledge here and information that the government has publicly shared with everybody. But I'm repeating it. And yes, I did have the pleasure of being the mouthpiece on this little issue. But, you know, we simultaneously have released this to the entire EB-5 community, and it's all over the China websites and the US websites and front page articles. CNN did an article, New York Times, I mean, everybody, LA Times did a feature story on this. It's really not big news today because nothing is happening that's adverse. Those people who've been scheduled for interviews in August had their interviews and got their green cards. Those people who've been scheduled in September have had their interviews, will have their interviews, and there's going to be a handful of people in Guangzhou where they're missing a document or something, and if the interview is September 15th or 20th, you know, they're going to be told, oh, come back in October to pick up your green card. Big deal. I mean, real big deal. You got to wait an extra week or two, so who cares? That isn't the issue for this year. The issue that we are going to talk about today is, what about those people who filed 1 day or 1 week before, scratch that, the principal applied 1 day or 1 week before the derivative turns 21? And what is that person going to do? So in a nutshell, what that person is going to have to do is, if at the time of approval, the whole CSPA analysis has 2 snapshots, 2 balance sheets. One is what happens at the time of approval, because you do a calculation at the time of approval. And the calculation, honestly, the more you read it, sounds complicated, but at the end of the day, all you get to do is deduct the time the petition was pending, that is, the petition was pending, from the child's age as of the date of approval. And that, in a nutshell, gives you the math equation. So for those people who file, where the principal files very close to the 21st birthday, and you're filing today, or you filed in the last few months, yes, there is a potential problem. And there is a chance of age out, because if at the time of approval the numbers are not current for that principal applicant, then we do the calculation, we deduct the time that it was pending, and by the time it does become pending, the kid's age, CSPA age, artificially calculated, can be over 21. So there is an issue, and that's the big issue. and we need to do the math now. What we can't determine is if the kid is 19 right now and you file as a derivative, is that kid going to be safe? And the reason we can't determine that is we don't know what the date gap will be. Is the cutoff next year going to be 2 years, 2.5 years, or 3 years? Or could it go to 3.5 years? Nobody knows this. The State Department doesn't know this. So I'm giving you all a long soliloquy here. I'm giving you all a long intro, mainly to get time for people to log in because the first few minutes people are late. And now I'm going to go into the slides and go into the weeds. Pardon my poor humor. Please excuse me. I tend to make silly jokes from time to time. Some of this is going to be very basic for you, and I apologize for those of you who are seasoned immigration counsel. Some of these basic terms are going to be very boring. My problem right now is I'm dealing with an audience of people, many of whom who have zero knowledge in this arena. So, those of you who are experienced may just have to sort of answer some emails for a few minutes. Okay, so what is this slide? This is my brag sheet, blah, 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 walks on water, flies without wings, all about me, kind of boring. You can just Google it if you're interested. But and this one, for the first time, I added to my PowerPoint. Well, no, it's been my PowerPoints, but we don't give legal advice, blah, 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 because there's so many variables here. I don't want to be in a position where, you made the wrong decision. I'm going to try and give you some tools to make the right decision, but the honest truth is there are too many variables at this point to decide. I mean, it's always safer to just file in the child's name and not in the principal's name, but, many parents would say, well, yeah, but we want to immigrate too, so, well, fine, come up with another $500,000, buy 2 tickets. Oh, we have 2 kids. Well, okay, file one for the principal, and maybe you'll bring one of the kids in, but if both kids are, in the range of 19 or 20, suddenly you're in this horrible situation of having to buy 3 tickets or make 3 500,000. Suddenly it's a 1.5 million proposition here as opposed to 500, which could be a little bit of a turnoff for a lot of people. Although one could argue that's still relatively cheap compared to some other programs. Australia at what, 4.5 million Australian dollars. Okay, so enough. What is the quota? We're going to go into some things. I'm going to fly through some of these. I hope that you folks are stacking up your questions, because one of the things I like to do is answer everybody's question. There may be some questions, however, which are just a little bit too complicated to sort of handle in the 15-second analysis, so I may take your question, put in your email address. I actually should have it, and I'll try and get to all of your questions unless you send in 100 questions each. And obviously that's not possible. So, this act, EB-5 program, 1990, George Bush Sr. Oh, gosh, I just remembered an add-on last night that I have to talk about. So I've been mentioning the impact of the establishment of a China EB-5 cutoff next year. And I've mentioned that if that cutoff gets worse, we could have retrogression, which is not a good thing for many applicants. There's a really important thing to mention, is that all of this could be nothing. There is some hope that Congress will fix the problem. AILA submitted just the last day or two a letter to Cecilia Munoz, White House domestic policy chief and a friend of immigrants. And talk is that President Obama is going to do something good for us. Originally, it was supposed to be done about now. Now, the new one is it's going to be after the November election. So what if in November or December, President Obama decides to be bold. It's happened once before, twice before. Stop the bad jokes, guys. But President Obama could just do the right thing. You know, he doesn't have to worry about getting reelected. And he could switch the interpretation for family and employment to read families, not individual heads. Now, the congressional record on this statute specifically talks about 10,000 investors. Well, we don't have 10,000 investors. We have 3,500. We have 3,700 investors. I use the number. We have 4,000. We have 4,000 investors. We do not have 10,000 investors. We have 4,000 investors plus their families. What's the difference? Well, you know, the difference is 1.75 billion a year, or 3 times that amount, 4 or 5 billion a year. So let me ask you a question. Which one would you rather have? $1.5 billion a year or $4.5 billion a year? And let's extrapolate that into a 2 or 3 year deal flow analysis, and we suddenly have a program where we are bringing in $15 to $20 billion, as opposed to our current program where who knows how much is in deal flow. Is it 5 billion, 7 billion over 2 or 3 years? There's probably about 7, 8, some people say 10 billion currently tied up. We could turn this, or this program could become a $30 billion a year program if President Obama or Congress does the right thing by switching the interpretation to 10,000 investors, not 10,000 investors and their wives and children, which is the current interpretation. Now, IMAC 90, something very good. IMAC 90 changed the statute. And by the way, folks, I haven't done the finite analysis on this, but this is the position that AILA put forward to the White House. And the White House might just do something good for immigrants. This would improve the waiting lines for family immigrants, second pref, third pref, the Chinese and Indians are currently suffering. By changing the quote, it would pretty much make all the categories current. Is Congress ready to allow another couple 100,000 immigrants into the U.S.? You know, we don't know whether he's going to do it or not. Are they just going to do it for the EB-5 program? You do know that the sunset provision comes up in September 30th, 2015. Why am I not worried about the sunset provision? Regional centers expire on September 30th, 2015. After that date, your petition, it's about 400 days from now, your petition will require 10 full-time jobs per investor. This regional center indirect job count thing is gone after September 30th. So why am I not worried about that? Look, folks, I don't have a crystal ball. What I do have is a little bit of experience in old age. Despite the picture you saw up there, the beard's gone gray. That's a picture from a couple years ago. I have age and I have wisdom. Not so sure about the wisdom, but I have the age. And what I do know is there are 4 bills expiring. One is the Conrad program for doctors in underserved areas. One is religious workers, the generous interpretation, religious occupation or vocation, not only ordained. And number 3 is E-Verify. There is no ways Congress is going to allow E-Verify to expire. Personally wish they did, but they're going to renew E-Verify. And my feeling is they're going to renew the Regional Center program for another 3 years. Maybe make it permanent. If they don't, all we've got left is the direct program, 10 direct jobs. And all this money and deal flow and all these projects are in peril. And yet I'm not worried about that. Again, this is not legal advice. I think Congress is going to extend it for another 3 years or 5 years. And maybe Congress will also do the right thing. My hope is that President Obama does this by executive order in November. I think he has the authority to do it. The president has broad authority in the immigration arena. And by the way, the Senate passed 774 last year, which removed the or changed the count from from individual visas to families or petitions. So a bill already went through the Senate last year, which removed the problem. Unfortunately, the House didn't move on it. So is this problem going to be resolved administratively by President Obama? Yeah, I think we've got a chance. Is this problem of the expiration of the regional center? Yeah, I think it's going to create a little bit of double uncertainty, because just at the time the China cutoff is established, and just at the time we start having retrogression on it, it goes from a 2-year wait line to 2.5-year to a 3-year wait line. What happens? We also start approaching the sunset date. I guess in finance there's a term, triple witching. This is going to be double witching. Two things coming together more or less at the same time could create some anxiety. And, you know, I keep talking about China investors because, let's get real, folks, over 80% of the program are Chinese investors. The State Department works off the anticipation that 85% of the investors will be Chinese investors. And we're talking mainland China. We're not talking Taiwan, Hong Kong, and Macau that are separate, or even people who can cross-charge to one of those countries. Okay, so let's go back to our little script. I just wanted to give you that little divergence, if that is the correct phrase, and little cause of optimism. You know, the world is not coming to an end, at least not this Friday, maybe sometime in the future, but not right now. Things have a way of working themselves out. So I'm a little bit optimistic that all of this will come together. So let's fly through our slides and see if there's anything interesting here. I was talking about Charlie sent this notice out, and he put this thing in my hand. I could read it to you, but it's on the AILA website, that visas are unavailable for September. Oh, big freak out. They're unavailable. Unavailable for who? All these appointments are already scheduled. We have like a whole bunch of people scheduled for August and September. They're going to go to their interviews, and most of them will get green cards, because when you apply for a green card abroad at the consulate, they not only give you an appointment, but in that file is an immigrant visa reserved. The difference, however, is when you adjust status in the U.S., which is only a small percentage of these cases, they do not give you a green card in the file until the case is approved. So if you go to an adjustment interview on September 29th, I can almost guarantee you and the interview goes well, if there is an interview, because they waive most of them, by the way, if you're adjusting in the United States. And the officer is going to say something like, oh, great, everything went well. Let me call Washington, get you a visa. And he's going to be told, no visa. We are out of supply. How do you think of visas? For those of you who are inexperienced, think of them as commodities. Think of them as oranges. There's 10,000 oranges come on the market. And, you know, you're right at the end, 9,998 or something like that, and there's no more oranges left. So they say, all right, well, a new fresh shipment of oranges comes October 1, 10,000 new ones on the market. What's the big deal? Come back next week. You know, you go to the donut store and all the donuts are gone, and they say a fresh batch will come out in half an hour. Can you wait? Well, I can wait half an hour. Pick up my donuts, oranges, visas, whatever you want to call them, and the supply's out. So in the adjustment context, it's different from the immigrant visa process. And when you get into CSPA and into the lock-in stuff, it's also different. Because basically the lock-in procedure, which is the second phase of CSPA, on the one hand, you do a count at the time of approval. If it's retrogressed at the time of approval, ouch, because you have to wait until the number comes up to do the analysis. That's why March, April, and May next year becomes so important. And by the way, for developers, it's important because they have to figure out and regional centers, the issue of job count. If there are these long delays, will there be material changes in the business plan? Oh, it suddenly took another 2 years to do this. Do you have to make material changes in order to survive? And are those justifiable? So those are all some of the issues that we get in. So really, this thing was just a warning for next year. Next year, we may not have a problem because President Obama may do the right thing. And Congress may do the right thing by extending the program and counting. But are they just going to do it for EB-5 and not do it for EB-2s and 3s and all the other people? Gee, I can't see just the rich people being able to get additional visas, although it does make sense. You know, we give 65,000, I think that's the number, 65,000 visas every year to the sibling category. Now, my own sister immigrated under the sibling category. So, you know, that's great. But let me tell you what happened. She came here, found it too boring, stayed for a year, and went back home to be with her kids. Wasted visa. I'm just saying in this case it was a wasted visa. But these people wait 14, 15 years, and then they finally get to immigrate, and they come to America, and then they don't really like immigrating at that age because it's harder. It's easier to immigrate when you're young. So, you know, is that inappropriate? I'm not going to get into this debate. That's not what you want to listen to. You want to know about your clients, Chinese immigrants that you filed for, and what are the solutions, and are there solutions, and what to expect and how to predict and deal with that. We are actually planning a second webinar on the 24th. Sorry, these dates sort of pop up and don't pop up. We're also doing something interesting tonight for the first time. We are doing another broadcast or a different version of the same webinar with simultaneous Mandarin translation. My Mandarin is not very good, even though I am married to a Shanghainese woman, and after 25 years I should have learned Mandarin. I only know when I'm being spoken about. But I do have in the room with me right now 3 fluent Mandarin speakers who will be translating for me and who are very knowledgeable in this area. So the visa bulletin was a warning. Let's run through our slides. What is the backlog? This is kind of simple stuff. A backlog is what we're going to have next year. In May, June, July, August, we're almost certainly going to have a backlog under the EB-5 Chinese priority date only, none of the other categories. And then we have a waiting line. What is a priority date? In the EB-5 context, it is the day you file your 526. You look at the receipt, and it's got receipt date, which effectively becomes the priority date. Sometimes it's received 2 days afterwards, but it was the date that it arrived, was filed. If you file it online through the ELIS program, or you file it via FedEx. So that's the 526. So the question then becomes, are you eligible to proceed to the second step? No combined processing. You can't file your 526 together with your adjustment. So you have to get your 526 approved first, and you have to be before that cutoff date. So you have to have a visa, has to be available before you can file. So once a visa filed to adjust, that is. So visa availability is something experienced immigration will know about. You have to have a visa current available. At the moment, it's current, will continue to be current for the next 6 or 7 months. So this problem is not really a big problem in the next 6 or 7 months. You get your approval, you file your adjustment. One of the problems is getting an interview in Guangzhou can take 5 or 6 months from the time your priority date, your petition is approved. So the question is, will Guangzhou start expediting, and will NVC start expediting cases that might age out? Can we ask immigration today? In previous lives, we were able to do this. We write to immigration, say, please expedite my 526 because I've got a potential age out. The problem is nowhere, other than my blogs, maybe Charlie Oppenheimer's on tape somewhere as having said that it'll happen next year, but he's very vague. He won't give us the exact amount because he's just giving us a warning. So is immigration going to act on that warning that it's going to be cut off and allow us to do expedites? I don't know. We're going to have to try. Will NVC help us with expedited processing in the event of an age out? You know, once that cutoff is established, or once it's formally announced, and it has not been formally announced, the only thing is we got a warning that's formally announced. By the way, a year or so ago, Charlie Oppenheimer in the State Department said we were going to reach the cap of 10,000. And we did not, because there was a slowdown in adjudication. So he's a little bit cautious now. The number of cases, he didn't hit it. He thought he was going to hit it the year before, and he didn't hit it. Now we finally hit it this year, so it's real. And it's created some anxiety. And we have to understand that there will most likely be a China backlog. And therefore, the data filing becomes very important. And having a visa available is very important. And understanding the difference between a backlog, a priority date, visa availability, and retrogression is very important. We cannot throw these words around. They are all defined terms, and we have to be familiar with all of them, and all of you will be familiar with all of them. So this was not a visa retrogression. Okay? The visa bulletin, you all know how to find it. Just Google the term visa bulletin. You look at September 2014, it has not been officially amended. That is why if you're in the United States and you get a September 526 approval and you want to file your adjustment in September, you can do that. If a visa was truly unavailable and they had amended the visa bulletin, you would not be able to file your adjustment application. So that's the story behind the story, the real story. I hope all of this is clear to you. So unavailable simply means that we've reached the full quota of 10,600. By the way, next year, the quota is going to be 9,900 or something like that. And it's like, what? Bernie, how do you know this kind of thing? Well, the government does a calculation. Explaining it, listening to it. You know, unused first preference, trickle down. This one trickles aside. This one trickles up. You know, one of the solutions is unused fourth preference trickling down. Currently, unused fourth preference can't trickle down, but unused first preference can trickle down. This stuff gives me a headache. Trickle sounds like rain to me. It rains visas or something. Bottom line is the guesstimate for next year is we'll have about 700 less visas for the 2015 allocation, which is wonderful. You know, on the one hand, you know, we're going to have this cutoff. On the other hand, we have less visas available. Please, Congress, do something. Please, President Obama, be bold again and solve the problem. And hopefully they will. I think they heard that plea. Okay, no problem. I've already said this. Some of this is repeated. I apologize. But the bottom line is no impact now. The impact is going to come in the next 6 to 7 months. If you can finish processing before March or April next year, this is good. If you can finish processing before March or April next year, this is wonderful. Clients who are dragging their feet, or EB-5 applicants are dragging their feet and returning their packets, are making a big mistake. They need to get those packets to you now. They need to get the documents in. You need to get those packages to NVC. You want to get scheduled before a cutoff date is established. And we don't know where it is. You know, the demand could be so high in the next 3 or 4 months, they could start it in January or February, and we have the problem 4 months from now instead of 6 or 7 months. But nobody knows this. It all depends on the speed. For example, a really important factor, they currently allegedly have about 75 people at the IPO, the Immigrant Investor Processing Office. And they were talking about taking it up to 100. If they start approving a bunch of cases or a couple big projects with like hundreds of investors using the deference policy, and suddenly all these new cases in the system could impact the pipeline. But really, it takes 5 months to get to Guangzhou. So the cases that we currently are in the pipeline are those that were already approved. So we're more looking at the cases that were previously approved. I mean, let's get realistic. Current average adjudication time, 13.4 months. That's an average. Folks, you know, we got so many at 16, 17, you know, often the mandatory RFE, you know, they don't regard those as past due. So many of the petitions are coming out are taking 15, 16 months, 18 months to get an approval. So if they establish a 24-month cutoff, what kind of big deal is that? It's only adding an additional wait time of, you know, maybe 6 months until your visa number becomes current. But if you filed just before the kid's 21st birthday and you have to wait 6 months, this is not good. At that point, you want the petition to be pending as long as possible. If you have substantial cutoff backlogs, if the wait line is 3 years, you want your petition to be pending, or 2.5 years, you want your petition to be pending as long as possible because you get to deduct only the time that petition was pending. If, in fact, the cutoff has not been established, then you actually want the petition to be approved as soon as possible. So it's only when you get substantial cutoff backlogs that you want the petition to take a long time. So some of those cases, you know, that have been pending since 2011, that kid gets to deduct 3 or 4 years from their actual age. It's a whole lot more time they get to deduct. So that only comes up when you get substantial backlog. So we've got to start looking at some of the concepts that we've been dealing with differently, and the exact numbers are going to depend on exactly how deep the gap is. All right, so this is a story. I already mentioned this. If you've got an interview in September, you'll come back in October. Big deal, no problem. This is a question that I got. I thought I would answer it. You know, immigrant visas are valid for 6 months or until the medical expires. Just remember that other new little kinky one. But the simple bottom line is that that immigrant visa, and they have to look at the date of the expiration, is not impacted by any of this. Once they have that immigrant visa, they don't have to worry about retrogression or cutoffs or any of those things. They still have 6 months to enter the United States, set foot in the U.S. Many folks, unfortunately, haven't settled their fares, file for a reentry permit or whatever it is, go back home, or settle in the kids into school, etc., etc. By the way, a lot of my clients love delaying their interviews. Oh, this is not convenient. My kid's in college. They got finals right now. This is where, if you're the lawyer, you have to be the boss and say, I don't care. Take the kid out of school for a week or two. This is a chance. If you don't do it now, you could be caught in this cutoff backlog date. So immigrant visa interview is valid for 6 months. Second unrelated point is you absolutely must, repeat, must attend that interview and not delay anything, because you want to get to that finish line. So at the time you get to the finish line, there are some oranges still available, or visas, not having to wait until your number comes up or gets called. The so-called waiting line, the cutoff system. I always like to use that analogy where you go to your favorite bakery on a Sunday morning and you have to take one of those little tickets and wait until your number gets called. This is a similar system. They're going to set up a waiting line system for Chinese applicants. They have to take a little system, and even though they get to the front of the counter and they say, I'll have a dozen of those lovely donuts, they are told, sorry, you have to wait, until the new batch comes out, and we don't exactly know how long that will. In this case, we do know how long it will be, because every month around the beginning of the year, they will publish, scratch that, or about the beginning of every month. So you go to the Visa Bulletin, the Visa Bulletin normally comes out about the 8th, 9th, or 10th of the month, and you effectively have about 6 weeks warning about what's going to happen. So you get about 6 weeks warning. Hopefully the State Department will give us more than 6 weeks warning when they publish the Visa Bulletin as to when the cutoff date will be. So what am I looking at? Well, Bernie Wolfsdorf is going to look at the Visa Bulletin on March the 9th. That could be a Sunday, so, may have to switch it. Bernie Wolfsdorf is going to calendar April the 9th, because those are the magical dates. March 9th, April 9th, maybe February 9th, that they're going to announce the cutoff dates for the next month. And when that hits, that is the big news. When the visa cutoff date actually emerges for the first time, that is the big news. The big news of what happened on August 23 is not big news. That was a warning shot. The real big news is going to be announced on those dates. Or maybe Mr. Oppenheim will announce it even earlier. But effectively, that's the big date. So let's see if we can go through any of our slides that are interesting. Mainland born, I already mentioned that. So if the principal applicant's spouse is from a different country, and the joke that I've made here is, people are going to want to marry people who were born in Hong Kong or Canada or France or whatever, and then you cross-charge that other country. I get this thing, well, what if the child is born in Hong Kong or Canada or France? And the answer is, who cares? That's not relevant. Unless, of course, the child is the principal applicant, in which case they don't have any problem. This problem is only going to apply to mainland-born people. And it will not apply to mainland-born people if they have a spouse from a different country. So my wife, who is born in China, if she was a principal investor, would not have a problem because I was born in South Africa. Yeah, that's the kind of phony English accent that I have. Pardon me. Don't quite speak the Queen's English, but, a version of it. It's reasonably acceptable. It's kind of got the South African twang to it. But hey, what can you do? Stuck with it. So here's the big stuff. Is May 2015 the big date? I think it is. The third quarter of 2015. But, I don't have a crystal ball. Yes, I have had the privilege of presenting with Mr. Charlie Oppenheim 2 or 3 times. I will be, hopefully, waiting for the invite, but they're telling me it'll happen. October 22 or 23, Mr. Charlie Oppenheim will be at the IIUSA conference in San Francisco. Hopefully, many of you will be there. Again, we'll have a chance to discuss some of these and update. I don't know if we'll have any critical information at that point, but it's going to be a fun conference, and San Francisco is always lovely to visit. Anyway, a little plug there for IIUSA's conference. And so why did all of this happen? We have a new USCIS director. Ali Mayorkas is still there, Assistant Secretary of DHS, still watches the immigration issues, thank goodness. Let's hope he's watching over us. Not sure. He has a lot of responsibilities. But we have a new director, Leon Rodriguez, and he announced, which anybody can tell, USCIS has been publishing performance data very interesting to read. The wait line for number of petitions has gone from about 8,000 in the pipeline to 10,000 in the pipeline as of June 30th. 10,300 526s in the current pipeline. With a 77% approval rate this year, as opposed to 80% last year, that's a bunch of petitions. Wow, huge numbers. 3,000 alone filed in the last quarter leading up to June 30th. And 66.5% usage for every petition. So, basically I take the number of approved petitions and I multiply by 3. So, if we have 5,200 approved petitions, 5,300 approved petitions, which is what we're anticipating for this year, extrapolated based on current approval rates. I should actually get my chart. Believe it or not, I'm talking from memory. I should really look at my numbers. Scratch. I had a file here with the performance data. And I kind of know these numbers. Let's scratch. Found them. Extrapolated 526 approvals for fiscal 2014 is 5,208. That's how many we're going to have this year. 5,208 approved. 10,375 in the system. It's a lot of petitions. But the 5,208 is going to use up all the supply for this year. The question is, how quickly is the government going to adjudicate those 10,375? And the question is, how quickly will they adjudicate the 3,005 petitions that were filed between April and June this year? We're getting about 1,000 a month on top of the 10,000 that are in the system. 10,300 in the system, 80% approval, 8,000 approvals, coming in at a rate of 1,000 a month. So as far as I can gather, they're not adjudicating 1,000 a month. They're just adjudicating, I think it's about 600-700 a month. So the number of cases piled up gets longer. And what if they increase the number of cases that are approved? Or what if they start denying a whole bunch? Are many of these old tenant occupancy cases that are going to get denied? Is this long waiting line going to discourage people from filing? And therefore, naturally, reduce the number of people in the waiting line? Maybe the market, I don't think so. If I was a Chinese investor today and I looked and I was listening to this webinar, what I'd do is I'd turn around and I'd take out my 500,000 plus and I would invest immediately to get my place in the waiting line. Because I currently think that people who invest right now are going to get stuck with about a 3-year wait before they get a green card, 2.5 to 3 years. Most of my clients have been waiting about 2 years anyway. So it's an additional 6 months, 1 year. Big deal. That's going to mess up some derivatives, not only from an age-out point of view, but factoring in the OPT. A lot of these cases are filed for the kids. The kids are in the U.S. The kids are graduating. They get 12 months OPT. If they STEM, not so bad. They get a 17-month extension. But getting H's has become very hard. It's a lottery, 50-50 lottery right now. Even with a master's degree, it's 50-60%. Without a master's degree, 30-40% probably. So the question is, how can these kids stay in the U.S. if, in fact, their green card is not ready? Because they cannot file that adjustment until their number is current. So what would I do? Wait another 6 months? Wait for the line to get longer? Analogy. You go to your favorite bakery on the Sunday morning there's a fairly long line. What do? You walk away? You get in line. You get in line. The line moves. You get a seat. You have to wait an extra couple of months. Big deal. Or you just give up and, go to the supermarket and get your donuts. Sorry, that was a bad analogy, but yeah, maybe some people are going to go to Portugal or Malta or whatever. I don't, wonderful, beautiful countries, but Malta may not have the same educational system that the United States has in terms of quality of schools. So, yeah, I understand. People may just say, well, fine, invest $250, $300, buy a condo or whatever, get a green card. But for those who want to educate their kids, this is the program, and it's going to continue to be the program. Okay, I'm looking at the time. I wanted to keep this kind of short. Can you just have my tech guy, do we have a lot of questions lined up there so I can plan accordingly? You can read the slide if you're interested. You don't have to ask questions, but oh yeah, there's a couple. Wow, smart questions. So, okay, I guess there was a little voice problem for a minute. What is the quota for Chinese investors? Interesting. China is, and I had that number. I believe this year China will take 6,700 of the visas. But the bottom line is, technically, each country is restricted by 7.1% of the total quota. The good news, however, is none of the other countries even come close to using 7.1%. They use like 1%, 2%, Korea in second place. So because of the fact that no other countries come close, China effectively gets to gobble up most of the visas and, effectively takes over 80% of the EB-5 quota because none of the other countries have a problem. So there's kind of an interesting little question. Will the slides be available? Yes. What does this effect have on Chinese investors? Sorry, I'm trying to just clean out some of the questions. What does this affect the Chinese investors who have invested in $1 million non-pilot program? Yes, this affects people, Chinese investors. It's not the amount of the investment. It's are they orange? It doesn't matter how much you pay. $500,000, $1 million, $2 million, $3 million direct. It's based on the fact that you are born in China and not married to somebody from South Africa. That's the issue that we're dealing with at hand, and it's real, at least for next year. If I just filed the 526 and have not scheduled an interview yet, how will the new change affect me? It's not, the question is if you've just filed, anticipating 15 to 16 months adjudication time, the pop-up date is going to come before you get an approval. So when you get your approval in 15 months from today, or maybe 13 months from today if there's no RFE, your client may have to wait an additional period until their number gets called. That's how it's going to affect you. Sorry, I'm just responding to the questions that we have. What does, here's one. Do you think it is possible that USCIS would withdraw its 2.5-year rule and require job creation within 2 years of the conditional presence? Seems a 2.5 rule, though arbitrary, may help Chinese and many EB-5 projects that depend on these funds. Yeah, I think that they're going to have to recalibrate. This rule was based on the fact that the 526 takes 6 months to adjudicate. Ha, ha, ha. It doesn't take 6 months to adjudicate. So they said, within 6 months, and then you have to create these jobs within 2 years. So you add, and you get this 30-month rule. Doesn't work, because in the example we have with our $1 million direct, this Chinese national puts $1 million into his franchise, gets a 526 petition approved, but he's not going to get an interview in Guangzhou until his number gets called. What if that ends up taking 2.5, 3 years? He can't even come to the US and hire those workers. So everything has to get recalibrated with regard to the job count and the material change, because that business plan may not be implemented as indicated because of this delay. Interestingly, USCIS is doing regs, so hopefully they will address that. My very able colleague, Yi Song, discussed this when we were in Chicago. Didn't have enough time, but that is definitely one of the issues. So buy that tape from AILA. It's going to be available at AILA Agora. Little plug for AILA. All the tapes from the Chicago conference will be available. I think it was a great conference, by the way, so encourage you to buy those tapes, listen to the tapes, and see if you learned anything. Okay, I'm going to move away from questions right now and continue with my slides. Some of these are new, some of these are not. So I already spoke about this, 10,000 pending, coming in at 3,000 a quarter. That all impacts, remember, folks, 5,200 petitions this year will chew up the entire amount of quota. What if we have 10,000 approved petitions, which I don't think we will, but I think we could have 7,000 or 8,000 approved petitions come up in the next fiscal year. So that would seem to be that we would use up at least an additional 50% of visas, maybe an additional 100%, but we need 20,000 to meet current demand. How long will the waiting line be? Well, we think it's going to be 2 years, but it may stretch longer to 3 years or more. What are the consequences? I've already spoken about this very briefly. The big age-out issue, the job creation issue, certainly the chances that it's necessary to do material change. I'm not going to get into these too extensively because I want to try and keep this presentation relatively short. Here's an important issue. So the reason we don't have a problem this year is October 1, there's going to be 10,000 new visas come on the market. Wonderful. What about next year? What about October 2015? There's going to be another fresh supply of 10,000 visas. So we don't have a problem this year because we ran out so close to the end that it's not like an issue. So you go in to the store, there's no donuts left. Oh, you only have to wait 2 weeks and then they bring in a fresh supply. Next year, however, it's going to be different because we're going to start the fiscal year, October 2015, with an established cutoff date. It's not going to get current again. How do I know that? Well, that's what the government is kind of telling us. So the problem becomes a little bit more acute at that point. So for those of you who are not familiar with the visa bulletin, this is the current September visa bulletin, and you see in red all chargeability, current, China, mainland, current. Just Google that term, visa bulletin. So let's look at China's second preference here. Those people, second preference, by the way, is a bachelor's plus 5 years or master's degree, U.S. master's degree, bachelor's plus 5. Doesn't have to be U.S. masters, by the way, just equivalent masters. But not getting into second pref in any major depth. Look at the China cutoff date. India and China are the only two countries with a cutoff date for people with master's degrees or equivalent. Those people had to file. What if they filed their green card on exactly October 8, 2009? Well, will they be current for the month of September? Answer, no. It has to be filed before that date. So you would have had to file on October 7 in order to be able to adjust or schedule a final interview. So if your green card and your priority date, in this instance it may have been a perm filing or whatever, I-140 filing if it was national interest waiver, and you would have had a priority date of October 7 in order to be current. So what does this tell a lot of the Chinese kids with master's degree? It tells them that, you know, they have about a 5-year wait. If you had this kind of cutoff date 4 columns below under the 5th preference, it would be a little bit of a dampener. It would discourage quite a few people. And it may discourage quite a few people if we have that kind of 5-year priority date. It's discouraged a lot of smart Chinese graduates with master's degrees. It's so hard to get into the first preference category, even with PhDs. A lot of them just going back home, getting rich, and who cares? But a fair number stay, you know, pursue opportunities here, enjoy the wonderful lifestyle we have. I talk about Southern California. Obviously, not all of you are living in California. Just seems that 50-60% of the immigrants who come through EB-5 are living in California or New York and Texas, Florida, but mainly California. So that's the big deal. How do you get to that priority date that's listed up there? You notice the 3rd preference bachelor's degree category is not even that much more advanced. For those of you who haven't studied priority dates, these, as I say, move every month. They're announced every month around the beginning of the month. The operative date is going to be March 9 next year, April 9, where they're going to announce a priority date cutoff for China probably in May. So that's, watch the visa bulletin, everybody. We'll probably do another update on this so we can plan accordingly. Let's see. This is kind of for those of you who are experienced. What does unavailable mean? I mean, State Department says the visa numbers are unavailable, but they never amended the visa bulletin to show unavailable. Unavailable is when you have a U. None of these categories have unavailable. That's a way of shutting down the visa issuance completely. But you can also shut down the visa issuance completely by just moving the priority date to a much earlier date. So what if you put a cutoff date for China 5th preference of January 2010, 1/1/2010? Well, pretty much everybody who's filed since that date has an approval. I don't think there's too many cases in the system from 2010. By the way, there's apparently still some cases from 2011 and 2012 stuck in the system. 3 years. There are 526 petitions that have been pending more than 3 years. The good news for those folks, if they have derivatives, is those kids can deduct all of that time from their birthday as of the date of approval. So they may get an approval in June next year, and they've got this wonderful early priority date. And those kids can then deduct all of that time to create their CSPA age and pull them. I just finished a green card case. I had a Filipino following to join derivative 3rd pref nurse. The kid was like 25 at the time of his green card interview. 25. I think it's a record for me. Unfortunately, the Filipino 3rd pref had backlog. Look at it right now. It's currently at April, but, you know, it was much worse than that. The nurses have pretty much given up, but it took this poor derivative like 4 or 5 years to get the final interview because they were applying abroad. Okay, so let's try and run through some of these concepts. Unavailable, we don't see that too often. And I keep using this May 1, 2013. So instead of current or unavailable, we will see May 1, 2013. So I'm going to go back to my thing again, and I'm going to go to the little red C for China. And it is my speculation that in April next year, you will see the number May 1, 2013 in that block. I don't know this. But if that in fact happens, it creates the problem that we're talking about. And if the next month, that is June 2013, we don't have May 1, scratch that. The next month, which is June 2015, we have a number of March 1, 2013. So instead of moving forward, it gets worse the next month. That, folks, is called retrogression. And nothing else is called retrogression. So you need to learn all these little terms. So here again, nothing dramatic. If you have a cutoff date that's earlier than this, you can apply for adjustment, and NVC will schedule your interview in Guangzhou if you have earlier than a May 2030 priority date. Again, this is guesswork. We don't know this for sure. So, who will be impacted? I've run through these numbers already. There's nothing new in this slide. I'm talking about an 80% approval rate, 10,000 petitions pending. Crazy speculation that if we have 7,000 or 8,000 approved petitions, we currently going to use up the quota with 5,200 petitions. So what if we have 7,000 or 8,000? Well, we're going to use up a whole lot more than the quota. We're going to need at least 15,000 visas. And then all these pipeline cases piled up in the system. We don't know. I don't know if we need 20,000 visas. It may be that all we need is 15,000 to cover the pipeline cases. But this is kind of like a traffic jam. It gets worse and worse in terms of the waiting line. You know, you close 2 lanes on the highway and it gets worse. You close 3 lanes on the highway and the pile up, the waiting moves slower and slower. We don't know how many visas we need, and we may get relief, so it may not be that serious. Risk of aging out. This is the big one. For children who turn 21 after you file the 526 petition, again, all you get to do is deduct the amount of time to create this artificial determination. And when the petition is approved, you have to have the visa number current and available. They use this word available in order to move to the next step, which may be an adjustment or schedule the final interview. So if the priority dates are not current at the time of approval, the family, including the derivative, wait. And that becomes an issue. And that's where you can potentially have the age out. So what else? I've covered all the points in this slide. Second part, this is like confusing. And if you've been confused, join the gang. Immigration's been confused, State Department's been confused, this thing has been litigated again and again, whole bunch of cases on this seek to acquire thing. But this is the second step. If the person's CSPA age is calculated as under 21, they still have to seek to acquire a green card within 1 year of visa availability in order to preserve the derivative status. If they don't do this seek to acquire, what I call lock-in procedure, then the child's actual biological age controls instead of the so-called artificial CSPA age. And what are these steps that you can do to freeze the age. If the kid's in the U.S., invalid F1 status, scratch that. If the principal is in the U.S., invalid status, that person, together with the derivatives, can file to adjust status. But as we all know, there's no 245K under the EB-5 program. So they have to be in lawful status. And the question is whether you want to try an adjustment off a B2, very dangerous, tourist visa. Off an F1, sure. Off an H1 or L1, sure. But adjusting off a B2 is a problem. So one of the things you can do to freeze the age is file the 485. And at that point, you lock in the CSPA age. You don't have to deal with the actual age. For the State Department, they want a 260. They want the 260s filed in the fee bill, which does raise a question because it can take a while to issue the fee bill. Many of you, and this is strategy for the attorneys, you need to start bothering the NVC and say, look, you know, I'm anticipating an approval on this. I want the fee bill because I need to. If you filed the day before, you know, and there's going to be a very narrow window, you have to be ready to do that lock-in procedure so that the artificial age counts, not the actual age, if you don't have much wiggle room. So if we're backlogged at the time, it's a pretty serious problem because you've got to get that DS-260, what we used to call packet 3, plus the fee bill paid. Now, there's some protection by following to join form 824, which is a duplicate approval notice form. It is not clear that filing an 824 for the derivative, the principal files an 824. The 824 is supposed to be filed together with the 485 when you're filing an adjustment and there's a derivative abroad. That is the purpose of the 824 filing, to create a lock-in for that derivative. So if the principal is in the U.S., husband and wife, and there's an 18-year-old kid back in China, yeah, you file the 485 because the parents are in the U.S. on an L, the kid's back in China, and you also file the 824 simultaneously. That does the lock-in. But you don't see those facts in the Chinese scenario. They don't leave their 18-year-old kids back in China. We saw that in the Filipino nurse scenario where the nurses came out, they left the kids back home, and we had to file the 824s to protect them. But we don't see that in the China scenario where they leave the kids behind. Just doesn't happen very often, realistically. So, in the unlikely event 1 year passes before seeking to acquire a green card by taking the necessary steps and then the visa retrogresses, the derivative child ages out. You know, that is really unlikely to happen, but I do need to mention it. That's where the person has the approval, they have lots of time, and they just don't bother to file the DS-260 with the filing fee. So I don't think that happens. But if that does happen, and the visa numbers had retrogressed, again, using the term retrogress, they are already backlogged, but they retrogress again. A new 1 year period begins once the visa number becomes available. I know it's hard to conceptualize this, but you need to be aware of it. Those of you who are attorneys need to research it. This is complicated, super complicated. You read it, doesn't look clear. Read it again, still not clear. Sometimes many of the commentary, many of the attorneys, some of the blogs, when they write about this, they haven't got it right. I've seen wrong information out there, the retrogression issue. I've seen everybody using the wrong term. And we've spent a lot of time to try and get people to stop talking about this as a retrogression problem. This is a China cutoff problem. We have a China backlog, waiting line. We do not have retrogression. We will not have retrogression probably until June or July next year as we go into the fourth quarter or the final quarter of the fiscal year 2015. We are currently in the fiscal year 2014 that ends on September 30th. New fiscal year starts October 1. Okay, so how do we plan? I'm just bashing this one issue. Unless the quota is increased or derivative dependents are no longer counted against it, I'm expecting the backlog to grow to 3 years. But I don't know that. Could be 2.5 years. Could sit at 2 years, 24, 26 months, in which case it's not a big issue other than for a small number of people. For pending 526s that are unlikely to be approved before the end of this year, some applicants may actually want to consider the possibility of withdrawing and refiling with the child derivative as the principal. So the parent might, in certain instances, already decide on pending cases, recently filed cases, those cases we filed last week, for example. Does it make sense if we filed 1 week before the kid's 21st birthday to consider withdrawing and refiling with that kid as the principal? So the parent has to gift the money to the kid, and then the kid has to refile, withdraw the petition, pay a new filing fee, refile, got the kid protected, and, you know, or file a new petition for that kid separately right now. Pony up another $500,000. File a new petition for that kid if you can afford it, because the kid's likely to age out. Those are two of the strategies that we could consider. And then, of course, President Obama may go and do the right thing for all of us, and we went and spent an extra $500,000 and we didn't need to. Or Congress went and acted by counting number of investors and removes the problem of the China cutoff. That will start next year. Wow. We suddenly went to this funny little man called questions. I've been going for quite a while. I want to make sure all your questions are answered. Whoa. We have quite a few more. I'm going to see if I can get all of them. So, people are talking about audio connections. I hope the audio connection is still good. Is the audio connection? Yeah, I guess that was just for a minute or two. Stated in the regional center regs for job creating, wouldn't just a reasonable period apply and disregard when the visa becomes available? We hope that when the government publishes regs, they turn it to a reasonable period for job creation. Since the pilot program, by the way, we don't use the word pilot program. That was removed in the last extension. It is now, I still see they talk in the State Department about pilot program. There's no pilot program. There's a regional center program. Pilot word is gone. Only gets 3,000 visas, and the rest are left, this is overs from the 1 million non-regional. Shouldn't the Chinese investors investing in non-regional to get priority over? You know, that's a good question, but that's not the way the State Department is reading it as of the present time. So answer is no. Here's another question that's coming into my tech specialist. Can you explain more specifically about the potential impact of job creation when retrogression starts? Again, when the visa cutoff starts. You know, here's what I can specifically say about this issue. The current system of 26 months, the current law or interpretation is that the jobs have to be created in 2 years. And the 2-year period commences 6 months after the 526 is adjudicated. So the problem is that once there's a cutoff, it is not going to be possible for that immigrant to pick up their green card within 6 months of the filing of their petition. I mean, the clock is running on the requirement to create the jobs, but the investor's still sitting in China waiting an additional year for their final interview. So in the direct context, this is a huge problem. In the indirect context, it's perhaps not as serious in my view because you're creating indirect jobs. The money, generally speaking, is going to flow into the project from the time of approval of the 526, not from the time the immigrant actually arrives. So in the indirect context, which is the regional center context, I don't think this is such a big deal. But if in a smaller project, the investors don't come over in the direct context, it becomes a more serious issue. So the way I look at this right now is really the problem is for the direct jobs basically have to be on the payroll and will have to be maintained for a longer time. As far as I see it at this point, I don't think the timeline for the indirect and induced jobs will be affected. So I don't think regional centers have to be too worried about this issue. As most of you know, in the indirect or induced context, the jobs are effectively calculated on an input-output expenditure model. That's what we ordinarily see. So I don't think this additional waiting line is going to directly impact the jobs. One of the other issues that we have to examine in some depth is the requirement of maintaining the investment, that the money must continue to be at risk and made available to the business most closely responsible for creating the employment. And it is this at-risk investment that has to be sustained throughout the entire period of the applicant's residence in the U.S. So the maintain, and then there's going to be all sorts of questions about whether or not, and we will definitely need to get clarification from the agency on this, because the way it's currently written is that it appears to be necessary for an investor's capital to remain continuously invested and at risk in the job-creating enterprise all the way throughout the period of an investor's conditional residence. That is the way it is currently framed. And in the fund model type of investment, the return of loan funds to the new commercial enterprise, the NCE, prior to the removal of conditions can jeopardize an 829 approval. So that may have to be tweaked. That issue could, in fact, become a significant issue. We are pretty much out of time. We've got 2 minutes. Let me take the last question or two. Oh, well, thank you. Thank you for saying thank you. We always like nice comments. How would this affect investors' exit strategy? I think I just mentioned that in terms of having to maintain and sustain the investment all the way through to the approval of the 829. That's a big deal, because if the loan is paid off after 5 or 6 years, but the immigrant cannot get their green card till 6 or 7 years, we may not want that loan paid off. Maybe other people do want that loan paid off, but the foreign national does not want to get that loan paid off because they could get the 829 denied because of it. We will hopefully get clarification from the agency on that. Wow, another nice comment. Thank you. Somebody used the word awesome speaker. It's just a funny accent. It's not me. That's so interesting. Yeah, that's it. Actually, I just answered the question that came up. In the event of retrogression for loan models, when money is paid back, can the investment be returned to the NCE and stay in the NCA without being at risk? This is one of the unanswered questions. We need to put this one to the government. So, you know, basically, the investment is returned to the new commercial enterprise and stays in the NCE, so it's not paid back to the individual investor. Is that satisfactory? It's not being used for job creation once it's sitting in the NCE's pot. But then again, why does it need to be there for so long? Why is it only the Chinese people are going to be required? Can you pay off the others and not the Chinese? Yes, you can pay off the South Africans, but you can't pay off the Chinese because it's going to be sitting. That doesn't sound fair. And hopefully the government will recalibrate for that. Folks, we have been going, and I'm going to cut off the questions. Oh, another super thank you. You do move for regional. Wow, thank you. Wait. Thank you so much for being there for us. Oh, that's nice. Do you do more regional centers compared to individual EB-5s? Oh, this is a curious question. Yeah, we do more regional center cases. Everybody, well, not everybody. A lot of lawyers do more direct cases. The reality is that regional centers cases are still taking, I think, 80% of the total usage. So, yep. Thank you. There's another nice comment. Flattery is wonderful. That's what keeps lawyers going, their egos. But folks, I think we're pretty much out of time. I want to respect your time. Thank you so much for joining us. Until next time, we do have a scheduled date of September 24. I will have some other guests, so you won't have to just listen to me. I hope that you've learned something. I'm rebroadcasting tonight at 7 o'clock. With simultaneous Chinese translation, try and focus this to the market and help people understand what's going to come on the horizon. So thank you so much. Spread the word, and look forward to communicating with you all. Take care. See you in San Francisco.